Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 24th of February 2025, the defense filed motion in limine number 11 to exclude IGG evidence, and you will recall that in this case, Idaho versus Kohberger, they also filed a motion to suppress this very evidence under a Fourth Amendment theory, alleging that Mr. Kohberger's constitutional rights against illegal searches and seizures had been violated. That motion was denied by Judge Stephen J. Hippler. So now what's happening is they are coming back under other constitutional provisions to argue that the IGG evidence should be excluded. They're basically seeking the same relief that they did on the motion to suppress, only and arguing different legal theories. What are they doing here? So this comes now, Brian C. Kohberger, by and through his attorneys of record, and pursuant to the Idaho Rules of Evidence, moves the court for an order to exclude evidence of IGG testing and searches. This motion is based on Idaho Rule 16b 1.8, and presentation of such evidence would violate Mr. Kohberger's state and federal constitution. We go to page 2 to find out what portions of the Constitution is being raised here. You're not going to see the Fourth Amendment because that was an argument that has failed. What they're saying here is right to a fair trial under the Fifth Amendment of the U.S. Constitution and the 14th Amendment. That's the Due Process Clause of the United States Constitution. And also his right to confront the evidence against him and to have competent counsel under the Sixth Amendment of the U.S. Constitution. So we see the Fourth Amendment not even mentioned here. They go on to explain that a sheath was recovered at 1122 King Road in Moscow on November 13th, 2022. That, of course, is the sheath that is discussed in the affidavit of probable cause that was found at the crime scene. The sheath was tested using DNA STR methods by the Idaho State Police. They were brought in by Moscow Police Department. We also learned that in the affidavit of probable cause to assist Moscow Police Department. Why Moscow Police Department? This is their jurisdiction. The crimes occurred within Moscow. They called in, however, they invited in other law enforcement agencies to assist with the investigation, ISP being one. The profile was uploaded to the CODIS DNA database and resulted in no hits to known offenders. The Moscow Police Department, with the assistance of Idaho State Forensics Lab, transferred extracted DNA from Q1.1, that is the DNA from the sheath, to Othram Labs, located in Texas on November 22nd, 2022. Doesn't say here what we learned recently through the transcripts from the closed hearing on the motion to suppress IGG is that an official from the ISP Labs and an unnamed member of the Moscow Police Department physically brought this sample to be tested by Othram. They took it from Idaho to Texas, and then thereafter work began at Othram. Othram, we learn here, promised to preserve all of its work in this case in the engagement agreement. That's an engagement agreement that Othram had with the Idaho State Police, and proceeded to test the Q1.1 DNA using SMP techniques. Othram generated a, quote, profile, end quote, using SMP and began building a family tree for Q1.1, looking for the closest relatives of the sample in commercial databases that allow law enforcement searches. And they're cited here as GEDmatch Pro and Family Tree DNA. Then, on December 10th, 2022, Othram was asked to cease work on the case by the prosecutors, despite the fact that their genealogy investigation was incomplete. Then it continues to state that genome profile that you have generated on this case, any remaining DNA extract, any data generated on this case, and any other records, and then in parentheses, Othram has, in this case, and anything else laid out in the state contract with Idaho, until the Moscow PD and the Latah County POA communicate that such information does not need to be retained by Othram Labs. And we see a footnote here, motion in limine number 11, Exhibit 2, discovery Bates stamped 15. Going on now, ladies and gentlemen, to page 3. After Mr. Kohberger was charged, he swiftly requested discovery related to the IGG testing and family tree building that led to his arrest. And it's stated here, May 3rd, 2023, defendant's third supplemental request for a discovery. I'm going to throw in an opinion here. I don't know if this is swiftly, because Mr. Kohberger was arrested on the 30th of December 2022, and this discovery request, the third supplemental discovery request, all of the supplemental discovery requests are under seal, so the public doesn't know until now that this is when it was requested. This was May 3rd, 2023. This is more than 5 months later, so I don't know how swiftly that means. But in any event, we will go on and say here, Mr. Kohberger laid out the rationale for his request in his third motion to compel in a series of affidavits filed June 22nd, 2023. And then it goes through what happened while this matter was in Latah County, that there was a dispute over whether this information was discoverable or not. There were a series of hearings, there were affidavits that were filed, there were motions that flew back and forth. There was finally a decision made by Judge John Judge, who was the jurist in the case at the time, in October of 2023, that you can read. It's a very long order. It's a really important one to understand what was going on with the back and forth, the disagreement over whether or not this was discoverable, whether or not the state should have turned it over to Mr. Kohberger. The court order did grant in part that relief and ordered that certain parts of this matter, the IGG testing, would be turned over to Mr. Kohberger. And there was also in that order an interesting finding by Judge John Judge, in my opinion, that the people that were involved with this testing and also the companies were informants. Maybe not in the traditional sense, but that they were. And there were protective orders that were entered regarding the individuals involved in the testing. So their names are not known. And what Judge Stephen J. Hippler did was to point out in one of his recent orders that they don't share the same last name as Mr. Kohberger. So therefore, anyone who might want to go out there and try and look them up who they were, they have a different last name, please don't. The court, after hearing testimony from a number of defense experts, found that the defense had met the threshold required to show at least some of the IGG information sought as material to the preparation of defense, and issued an order for production of, quote, all the IGG information in the possession, custody, or control of the state for in-camera review. This is the order that I just spoke about. It was the order of Judge John Judge. It's dated October 25th. It's very long, 2023. If you'd like to read it, that's where you can find it on the docket. Then on November 30th, 2023, the state provided materials to the court for review. This is the in-camera. That means for Judge John Judge's eyes only. It didn't go to the defense, and it certainly was not put on the public record, along with the table of items. The listed items included materials from the feds, ISP emails, Othram emails and documents, shipment of DNA profile documents, and ISP Othram contracts. The court ordered release of the majority of the materials, with the exception of the genetic contract documents of MOU, and then we have to go on to page 4 to continue, between the ISP, Moscow Police Department, this is Memorandum of Understanding, Latah County POA, and Othram. Second order for disclosure of IGG information and protection order. This was entered by Judge judge on December 29th, 2023. After a review of these materials, Mr. Kohberger requested additional discovery materials in his 15th supplemental discovery request related to work done by Othram and the Fed. So now we're learning for the first time what they asked for in the 15th supplemental discovery request, because if you go and you look up the 15th supplemental discovery request, like the 1st through the 22nd, what they do is that the information they're asking for is filed under seal. So this is firsthand information we're getting as the public here. He sought materials to encompass essentially all of the materials that are normally produced, along with lab reports for scientific testing. The state objected, and Mr. Kohberger filed his 5th motion to compel. In a hearing on May 30th, 2024, this was before Judge John Judge. This came before the change of venue order that came in September of 2024. Extensive expert testimony was again heard by the court as to the necessity of the material sought. The requested items included, among other things, raw data files for SMP testing, standard operating procedures, SOPs, validation summaries, contamination logs, bioinformatics programming, and protocols. At the end of the testimony, the state, through Mr. Nye, argued the motion to compel, and in a striking exchange, Mr. Nye represented to the court, the court makes the decisions, and so we complied with that order, and we reached out to the feds and to Othram and said, you got to give us what you have. We've talked a lot about it, and we referenced a letter from the feds today. I thought the letter itself did a pretty good job laying out what they do and don't have, and what they have access to and what they don't. And then, in bold, we have talked to Othram. We've spoken to Othram since we have gotten this Exhibit N as in Nancy and provided them these requests. And we are not in the position, for example, request number 1 through 6. We are not fighting those. I'm not saying we are not going to turn those over. In my view, they fall pretty clearly under the court's order. End of bold type, and it's also italicized to emphasize this point. The issue is we go to Othram and show them these, and Othram says, we have given you everything. You have everything. Everything we have was given to the court and then provided to the defense. So there's nothing on this list that we are holding back because we think we have some justification. Transcript, May 30th, 2024, at page 84 to 85. She is citing to where Mr. Nye's statements to the court were. Items 1 to 6 in Exhibit N are the materials described above that pertain to the SMP DNA testing done by Othram Labs. Mr. Nye emphasized that Othram told the prosecution as to the specific reports outlined in items 1 to 6 of Exhibit N. Othram is just telling us we don't have it, so there's nothing we can do. Id, that means citing back to transcript May 30th, 2024 at page 85. The court then inquired. We have to go to the next page. When she speaks to the court, this is Judge John Judge. So Othram has said, you asked them and they said we've given you everything we have. Mr. Nye, yes. It at 86, this is where this exchange came from in the transcript. Mr. Nye reiterated that the state knew that if the documents listed in Exhibit N1 to 6 existed, the state had an obligation to turn those materials over to Mr. Kohberger, and with the rest of it, we are turning it over if it exists, and if we have it, that's all. Id at 92. That's page 92 of the transcript. In the court's order related to the specific requested Exhibit N as in Nancy, the court relied in toto, that's total, to the representations of the state, specifically referring Mr. Nye's statement about items 1 to 6. Quote, the state indicated that the material sought in this request does not exist, end of quote, order on defendant's 4th and 5th motion to compel discovery at page 8, June 14th, 2024. That's the order that was rendered by Judge John Judge. On January 23rd, 2025, now we're fast forwarding, this is post change of venue, which happened in September 2024. So this is now January 23rd, 2025, hearing before Judge Stephen J. Hippler on the motion to suppress IGG is what she's talking about here. On January 23rd, 2025, a hearing was held before this court regarding the suppression of DNA IGG and Mr. Kohberger's Frank's proffer hearing. During that hearing, Matthew Gamet testified regarding the state's relationship with Othram, the contracting process, specific information about IGG work done by Othram prior to its SMP data being passed to the feds. Mr. Gamet was involved in the original process that led to the IGG contract with Othram, and then it's cited to TX 1 to 2325 at page 89, which involved coming up with specifications for the scope of work for the contract. Mr. Gamet specifically testified that, quote, manuals, protocols were provided back to us as part of the bid, end of quote. Mr. Gamet also testified that the contract with Othram, and then she gives the portion of Mr. Gamet's testimony from hearing on January 23rd. So basically, if we look at the next several pages, what they're arguing is that the state of Idaho intentionally withheld certain discovery that should have been turned over to them when they first asked for it in May of 2023 in the applicable supplemental request for discovery that they had to go through a hearing, they had to bring in experts, they finally got the court order, then there were apparently, what they're arguing, misrepresentations made regarding certain things. And so for this reason, this is, if you go to the outcome or the ending of this filing, but you're going to have to go to page 16, and what the defense is asking for is sanctions for bad faith and for impropriety by the state of Idaho. They're doing exactly what they tried to do on the motion to suppress, but here in Limine, they want it thrown out. They want sanctions imposed upon the state of Idaho. Now, why is all of this important? It's the Othram work was turned over to the feds, and the feds who received it was on or about December 10th of 2022. Within 9 days, a tip was made to the Moscow Police Department, to the local authorities. Look at Brian C. Kohberger. That is, from what we know thus far, how Mr. Kohberger was brought forward to the Moscow Police Department, and then very quickly, by the 29th of December 2022, we see that the affidavit of probable cause was signed by Detective Brett Payne. It led to the order of probable cause, and then that led to the arrest warrant. So we will see now what the state of Idaho has to say in response to this in limine motion, and then ultimately there will be an opportunity for the defense to come back with a reply. The schedule was February 24th, deadline for the in limine motions. March 17th, deadline for responses to in limine motions. March 24th, deadline for replies to responses to the in limine motions. And then ultimately there will be hearings. I believe they will go for 2 full days because of the number of the motions in limine and complex legal arguments that are being made in some of them, including this IGG suppression, this IGG motion in limine, probably going to go the 9th and 10th, although the court's order of January the 31st only said the 9th of April, and if necessary, the hearings will continue on to the 10th. We will follow up with the state's response in opposition to this motion in limine in a future episode here on the Indie Zone. Until then, if you have any comments, any questions, please leave them for us. And as always, thanks for joining us here today.